Mr. Dreyfus, one of the claims the opposition's been making is that you released 130, 140 people before the High Court had released its reasons, and they keep insinuating that maybe that wasn't necessary. You only had to release the actual plaintiff in the original case. Can you explain why so many people were released? And this is a genuine request for information, and on what basis, given we hadn't seen the reasons?
What the opposition has said is simply not true. I had a statement that I made tabled in the Senate yesterday, and it makes it very clear. The decision of the High Court sets a new limit on the power to detain anyone in the same position as the plaintiff in that case, and it had to be implemented immediately. As you'd expect, the Department of Home Affairs is now undertaking an expert assessment to determine which people in detention are covered by the High Court's decision. Once that assessment is complete, and the criterion is not anything to do with the nature of the person, it's to do with whether or not there is a real possibility of them being removed to another country. Once that assessment is complete, any delay on the part of the government in releasing such a person would expose the Commonwealth officials concerned to personal liability for false imprisonment. The Albanese government cannot and would not ask a Commonwealth official to break the law. And that, apparently, is what Peter Dutton is asking us to do, to break the law, and that's what we will not do. We will not expose Commonwealth officials to being sued or to disciplinary action or the Commonwealth to potentially large awards of damages against the Commonwealth for breaking the law.
I might just add to Mark's done the law, let me do the political bit. What the coalition is saying is absolute garbage, and they know that. They know that they are out there telling lies, and they have been playing politics with this for weeks, and I get that you all have to report that, but let's call it for what it is, garbage and lies. James?
When you started practising 40 years ago, could you have imagined at one point in the future you would be an Attorney General who would assist in the creation of laws that preemptively detain someone on the basis that they may commit a crime? And secondly, where does a regime like this end? Riley buys a Ferrari, could it be arrested for preemptively maybe speeding?
Since you're going way back in time, the only time I've worked in politics before becoming a solicitor and a barrister was when I worked for the Victorian Attorney General in the 80s, which was when the Victorian government got to the regime that we now see in every state, which is preventative detention for sex offenders. A couple of states also have preventative detention regimes for violent offenders or another range of serious offences. And over time, since I started in practice, all Australian jurisdictions have come to adopt preventative detention regimes, which, as the High Court has made clear in the reasons for decision in NZYQ, is a power to be exercised by a court. On the application of a minister, to be sure, but the power is there to be exercised by a court. If there are many things made crystal clear by the High Court's decision, but that's one of them, and it's to say that ministers have no power to detain. That is a power preserved for the courts, and, as the High Court also makes clear, it's to deal with a real probability of serious offending. That's what the state and territory schemes look at. That's what the high-risk terrorist offenders scheme that was put in place in 2019 looks at. That's the model which the opposition is calling for our legislation to be modelled on, and it is.